It's a very good morning to all of you. Myself, Joyanto Bosha, working as an assistant professor in the Department of Computer Science and the convener of this program in the BBIT, Budge Institute of Technology. So as you all know that our college is organized this IP awareness program under the flagship of KAPILA, which is actually Kalam program for intellectual property literacy and awareness. To say about the KAPILA, it is to overcome the current limitations of our innovation ecosystem, especially in our higher educations. A systematic holistic effort is proposed which will create appropriate awareness regarding the need of IP filing, mechanism and methodology involved in filing IP in India and globally, especially among students and faculty of higher education institutions. So KAPILA will help in establishing the much required IP filing ecosystem in large number of education institutions and thus create a culture of systematically protecting new ideas, research and innovation having national and global relevance. The one of the main objective of KAPILA is to recognize, facilitate the intellectual property, innovation and best practices in higher institutions in India. So Dr. Kaushik Bagh is our today's speaker for this program and we have our respected DGA Bhavesh sir with us. So welcome Dr. Bagh and Bhavesh sir. So Dr. Bagh is currently working as examiner of patents, designs, Ministry of Commerce Industry, DPIIT, Government of India. He is PhD in chemistry from Indian Association for the Cultivation of Science, Masters of Science in Chemistry from Indian Institute of Technology, Kharagpur, and Bachelor of Science in Chemistry from Ramakrishna Mission Residential College, Narendrapur. So I would like to request our respected DGA sir to say about few words about today's program, as your speech always motivates and encourages us to conduct such kind of activities in our college. So sir, I request you to, sir, you can kindly just tell us some motivational speech or something about this program.
Yeah. Jayanto, let me reconfirm my audio. It is okay?
Yes sir, you are absolutely audible sir.
Thank you, Jayanto, for inviting me.
Yes, thank you. It's my pleasure sir. Sir, I am going to switch off my video to just maintain the bandwidth of this program.
Sure. Good morning to you all participants, our honored invited speaker, all the stakeholders of this program, my colleagues. I take it as my pleasure to welcome you all to this awareness program conducted by our departments in collaboration with the Department of Research from our institute. Specifically, I thank Dr. Bagh for kindly accepting the invitation from our side, and also the Department of Commerce and Industry for extending the necessary help. The part of appreciation and thank is also deserved by the AICT development. And the initiative taken by this is very much helpful to the institute for developing a wider audience of stakeholders for this very essential component. I hope through this awareness campaign, I will be able to educate a higher section of a broader community of stakeholders. I hope the participants will gain significantly through the deliberations we'll have during this course of this activity. And Dr. Bagh will be able to educate individual members participating in the event on the various finer aspects of IP related requirements. And as a whole, education community will be able to gain through this awareness campaign. I wish the organizers very best for this program. Thank you all.
Thank you, sir, for your important speech on this context. And as the sir told that IP is right now is a very important thing for all the academicians and all the faculty members and the students also. So in this context, I will just request Dr. Bag to just put on more light on this particular context. I think we have right now more than around 50 participants we have, and others are joining one by one. So if Dr. Bag, you are ready, then you can proceed with your topic or with your ideas.
Am I audible? Hello.
Yes, sir, you are audible, sir, very much.
Thank you, Dr. Bhattacharya, for the warm introduction, and Dr. Bosa for inviting me for the speech, and Dr. Sao for the invitation also. The program has been earlier conducted under the banner of NIPAM, which was conducted around, I think, 2 months ago. It was the basic of IPs has been discussed by other speaker. So now onwards, as I discussed with Dr. Borsak and Dr. Sao, I will concentrate on patent filing procedure or something like that, because I know the Budge Institute of Technology is one of the best institutes in the technological institute in West Bengal. So as per the Kalam program for IP awareness, there is something that they are providing financial assistance to the Institute of Higher Education for filing patent. So with that introduction of that is an assistance from Ministry of Education, their innovation cell, and also AICTE is conducting this Kalam program, and we, as a part of the IP awareness program, we are conducting the program for the students and the faculty of different educational institutes, and as per the procedure of this program, I would just give a brief introduction of IPs that has been discussed earlier under the banner of development. And now, then I will shift to the another part of the program, which is mainly focused on how to file a patent and how to search, how to do that. So, as I am an examiner of patents and design in the Patent Office of Kolkata, so we would like to first tell about the background of intellectual property. The property can be divided up to two, that is tangible or intangible. The tangible property that you can measure, which is a car, a house, a building, something like a cell phone, like that. That is the tangible property, which you can measure. But intangible property, which cannot be measured, like our intellectuality. Our intellectuality, which is within our mind, within our soul, that cannot be measured, measured properly with the some designated thing. But what we can do, that we can measure via our intellectual property. And how to measure the thing? We would like to tell that there is something called intellectual property, like patents, design, trademarks, geographic indications, or copyrights. This kind of intellectual property can be measured financially when you are filing that one to the government. That is the some basic importance of filing intellectual property to the concerned department. That's why we are here to discuss about intangible property of intellectuality. So, what is intellectual property? Intellectual property is a property that arises from human intellect, and it's actually increases human creation. It's a product of mind. It's actually protect your right. You can innovate something. That innovation, if you are not getting a financial support, financial aspect from this innovation, from your innovation, you would not be able to create another innovation, create another innovation for your intellectuality, for the actually the intellectual property. So that will exclude others. You can protect your intellectual property by filing a IP, and you can exclude and also you can commercialize and earn from your intellectual property as a creator of something like a product, like new process, like a new design, creativity. So that you can protect your creation as well as exclude others from using your intellectuality. And if they want to use your intellectuality, then you can utilize as it is a commercialization. After commercialization, it can be utilizing by others. But in that way, you can also earn from your creativity. That will also enhance the basic creation of your mind. So intellectual property, as we know, intellectual property, we can divide intellectual property into subtopics like patents, design, trademarks, GI, copyrights, and SICLD design. So this is the subtopics. These are the subtopics of intellectual property. So we will move to patents first. So firstly, we would like to show a diagram that it is a laptop. So in a laptop, you can see all of the intellectual property in a single frame. That's LED display. That is LED display is made of some chemical compounds and optoelectronic products that will so that will effectively termed as a patent, which is granted. Then the body of the laptop, as you know, the shape of the laptop is actually protected as a design. The Apple sign you see in the back of the screen, it will be protected as trademark. The user manual we get actually with the laptop, that will be protected under the copyright. And the layout of the chip, that is SICL design, that integral chip there has been, that will be protected as SICL design. All of the components of the laptop has been already protected with different kinds of intellectual property, and you can see that in a single product we can protect different kind of intellectual property in terms of different IPs. You can see patent design. Can you mute yourself, please? Could you please?
Participants are requested to mute yourself. Check carefully, your microphone is muted. There should not be interruption in between the session. Please. Sir, please continue, sir.
Jayanta, please see whether you can control the muting process.
Yes, sir. Yes, sir. I'm just
There sh-
muting. Who
there
is
should-
unmuted? I'll just muting manually.
Yeah, there should not be disturbance in between.
Yes, sir.
Dr. Bach, sorry for the inconvenience. Kindly, you can restart your presentation.
Am I audible?
Yes, sir. Yes, sir. You are audible, sir.
Okay. So if you want to protect his right, so he or she have to file a patent in terms of their equipment he created for fishing. So firstly, he will demonstrate how this machine will work, and it will how it will give the economic benefit to a person who is equally important to fishing. So there only there he files a patent, and when he gets granting order for the patent, like patent is granted for your product, then he can use this product. And then if some other person wants to use this product, like this fishing machine, for their utilization, he or she can ask the original owner to make it commercialized. And after he has commercialized the product, like patent or something like that, so then he can actually he can protect the you have already protected his right via patent. So only he can do that. He can ask for the patentee for permission, and he granted him permission only when he gets an economic benefit. So you see the original inventor is getting economic benefit with his intellectual property via filing a patent. So this is the basic of patent, and immense importance of filing a patent before before creating or commercializing a product. So these are actually examples of famous Indian inventions. That is nano car. It is very cost-effective car from India. It has been patented, and it will give the economic benefit for the middle-income families. Hepatitis vaccine, and it was originally actually too much of price, but after Indian scientists have been prepared this vaccine with 40 cents a dose. So it is giving economic benefit for the people. So it is getting a patent for India. Jaipur food, affordable prosthetics. You have already, I think you have known that in Jaipur food, it is very well known in the for the people. And moving on to the next session, which is design. What is it? We call design. Design is the ornamental or aesthetic aspect of an article, right? It's a shape or the design you got from actually a kind of range of products. That is You will see a sari here. This is a specific uh, there is specific design out of the sari or the product. In the fan, there is a specific design there, and if one has designed actually invented the design, he or she must have utilized his brain or innovation for protecting itself. So, without protecting, he or she would not get any kind of economic benefit for designing it, and that will not encourage any kind of innovation. So, he or she can file a design in the patent and design office, and thereby, if the originality of the work is proved, then he or she got a design registered for the product. After that, any company or anyone is using this kind of design in their product, he or she have to pay something to the original innovator to utilize this. It is it's another example of the product, that is, you see a specific shape of bottles, specific shape of cups, mugs. This all kind of thing can be registered under design. Moving on to the trademark part segment, the concept of trademark is in any word. Actually, you can use any catchy word to your product to give it a specific significance, a specific protection. So the concept is already known that any product you have in the market, to give a catchy name, catchy word, they can recognize the, like you already know that Reebok, Adidas, this kind of indicates a specific brand of product. So you have brand fascination, so you can go for the Adidas product, you can go for the Reebok product. This kind of signature, this kind of word, name, symbol, or device is a concept of trademark. You have to file a trademark and for the product, and your name others in terms of quality or in terms of economic. It will actually identifies and distinguishes the product from the other product available in the market. So subject matter of the trademark, like you can see already the Google, McDonald's, Coca-Cola, it's kind of a product signature, and the product has been named, has been branded under this sign or like this name, Google or Adidas, like Naukri.com or Deal Bangabo, this kind of, this is brand for the product. So it will get recognized at the time you spell it from your mouth. So it is really beneficial for the product launchers or the company that you can that they can file the trademark. Trademark is the originality. When it is filed, it is called as a TM sign. You can see that sign will be there upon this TM. So it is already under approval, and after it is getting registered, you get the R sign. It is registered. So you can actually you can no one can use your sign. If anyone can you use your sign, and he only uses his after getting your product, that your product only registered under this brand name. And if anybody others or from the company or other than this company had used this logo or sign or trademark, then you can put an infringement request in a court. Then the law will sue or something like that, legal procedure against him, and you will get some benefit from that also. In this way, you can know recently trademark infringement case has been filed in the court, and if the couple has been filing pentathlon like Bharat Pay or Phone Pay, this kind of cases has been running on in the courts. They have filed infringement against these companies. And in fact, this is copyright. Another section of the is well known. That is when you are doing a creative art, right? Or you're writing some essay, you're writing some novels, then you can only get benefit when you are protecting this your art under copyright. Actually, copyright is a creative mind can create an art or something like drawing. It has been seen that many creative people has been writing or drawing or reciting or making drama online or offline, but they are not getting any economic benefit from their work, and it will not encourage them to create another work of art, another work of drama or kind of. So as the society progresses and with his arts, with his reflection on his arts, so it is important to protect their arts in terms of their filing their copyright. So the copyright you can find in these domains like literacy work, artistic works like dance, dramatic work, musical work, sound recording works, and cinematographic films. So example of copyright controversies are cases. You can see that Three Idiots controversy from Chetan Bhagat, who claimed that this story is based on my novel, and later on it has been solved somewhat that is fine, and they have been given some. Chetan Bhagat have been given some kind of credit for the story. In that way this case has been solved, so you can find infringement if you can, and thus I have controversy is already actually in here already. So we'd like to move the next session to the SICLD, semiconductor integrated circuit layout design. It is an integrated circuit layout design. So the people will understood that there's semiconductor and transistor in the secondary of the secondary elements are in the semiconductor or insulating material. They have been actually they are prepared by the as- anyone is actually doing something in the presentation. I don't understand how its red mark is coming. Dr. Bosap,
Yes, sir.
anyone is doing this kind of issues, red mark is here. It was not in my presentation. This thing. I think anyone is infringing like this kind. Like just seen as someone has changes this sites also.
Sir, is it
So
possible to okay that
actually, you are controlling the.
yes, sir, just a minute, sir. Give me a minute.
Yeah. Dr. Basak, shall I continue? Let me
Yes, sir, you
continue.
can continue, sir. I just informed our technical head, IT head, so
Yes,
he is
yes.
just looking onto it.
Okay, fine.
Yes, sir.
So this is essentially, I will say that the person who will design in something in integrated chips. I know that integrated circuit, so they can register or protect their design by filing an SICLD design in the parent office. So I will move next to the next section of geographical indications. As you know, the geographical indication is an indication that identifies a product that has a specific geographical origin. Like I know the you know the Darjeeling tea. So Darjeeling tea is originally from a location called Darjeeling. That will give a significance to the originality of the product. If you can cultivate the tea in the other part of our country or other domain of the country, so that will not be recognized as Darjeeling tea, and that will not get the economic benefit from saying that the tea is from the Darjeeling tea or something like that. So this will actually identifies the product. Actually, it exclusively identifies it is a Darjeeling tea or some Mithila painting or Magdi Pran or this is Silau Khaja. This kind of giving recognition to the specific part of the country. So with naming something of this product is famous for the Darjeeling is famous for as a tea as it is getting we are getting for is for Darjeeling only. So in this way we are recognizing the product via the this specific area or specific part of the country. So in this way the geographic indication is actually well known. So the term or variety of the various IPRs we discussed that patents can be registered, patent can be granted for 20 years, design can be registered for 10 years, it can be extended up to 5 years. Trademark, a trademark it is indefinitely and initially for 10 years. Then geographical indication it is initially for 10 years. Copyright it is after the lifetime of the author it can be protected up to 60 years. Then the copyright is actually not valid. So who can apply? Person or individual they can apply for patent, design, trademark and trademark. But for geographical indication is one person cannot file. And actually it recognizes a area. So the area and significance have to be filed by legal representative from the area. So it actually recognizes that area with this via this product. So geographical indication cannot be registered via one person. So apart from geographical indication, all of the intellectual property can be protected by one person. So this is the part 2 of the webinar. The first part was discussed about the basics of the repair IP. So second part will be we will be discussing about how to file how to file this product. So understanding the patent application. Understanding the patent application. How to understand what is the problem statement that is discussed. Actually, when we want to file for a patent, we have to look for the problems we have in solving in the patent. So first, we actually look for where is the loopholes in innovations. Other innovations we have already. Actually, significantly, if we innovate some machine in I think I have already that has been told I told that there's a fishing machine which has been invented by one person. He or she, the inventor, have to look for the problem being associated with other fishing machines in the world. And when he is looking for the problems associated, then he can tell in the patent specification that what is the solution he got for the problem So this is the original thinking before filing a patent. So after getting the original solution from the other asso- associated problems with available products for the fishing machine in the other part of the country, then you can file a patent, and you are proposing a new solution for the fishing machine. So it is kind of a new solution you are giving for a new invention. So the first you have to understand how to file a patent application. So when we discuss about patent, everyone or somebody already in the mind that thinking in the mind that why we go for the patent publication, and why we don't go for the non-patent publication or paper publication. Actually, what is the difference? The difference is the technical solution. We are in the patent. We are giving a technical solution to the problem. But where in the literature, we are actually getting the inferencing finding research. Basic research has been discussed. Basic findings has been discussed, and one of the basic thing is that the technical solution is industrially applicable, but in the paper or non-patent publication, there may be some findings. The very good findings or very innovation is there, but that cannot be industrially applicable. That is only a basic research has done, and this is actually increasing the depth of knowledge. But in creation of innovation or economic benefit for the people in terms of applying in the uh, technicalities like whether it is industrially applicable, non-patent publication or papers is not too valuable. So we don't discouraging anyone by saying not filing non-patent literature. It's also a basic thing, but when you are getting a practical approach, you are getting that it can be practically approachable, practically done, and it can increase the economic benefit or commercially applicable, then you can go for the patent first, patenting your product or process. Then you can go for non-patent publication like doing paper. So first you have to you can utilize your intellectual property by filing a patent. Then you can go for the product or the non-patent publication. So what is patent? I already told in the first slide that the patent is something that has not been made before. It is a product. A process is creating something that has been never been made before. A process. So the product and the process both can be patented by filing it. And there is a things to note that invention has to be some technology in the field of invention. So technology is the basic thing. So if you don't patent your invention, other people can make all the profit out of it. This is a definition of patent. Why to patent actually in the Cambridge dictionary is other. If you have published some paper, in the paper you have given some solution to a specific problem of the society. Uh, but it can be used by other, it can be used by any common man to utilize this process or this product where you are not getting any economic benefit out of it. So after getting it patented, you can go for the non-patent literature or publish a paper. But after you patent, no one can copy your right, one can take your right away. As you have a patent to this product on the process, then you have already been given right, the legal right as a patent holder. So you can sue the person who is want to copy your patent and use in their innovation or their product. So in this way, you can you can file a patent. You can have a patent in your name. And other thing is that when this patent is very much commercially applicable or industrially applicable, then the industry persons like companies will approach you that please give the right of the patent to them. So you can also give the right to them and ask for the economic benefit you can. So in this way, you can get benefit from a patent where in publishing papers you are only getting the actually a scholarship credential. So other than the scholarship credential, there is nothing else you can contribute or you can economically benefit yourself. So it is the importance of filing a patent. So before filing a patent, I will tell you the forms or tell about the forms which is required to file a patent. There is form 1. This is a grant application for the grant of the patent. This is a basic, actually very basic form. What is the name of the inventor, name of the invention, and these kind of informations are there. And form 2, it is the important part of the patent. This where specification has been, all the description of the patent has been disclosed in the form 2 of the application. So you have to describe your or process via form 2. With what kind of proposing, what kind of by your patent application, that process will be in the form 2. And the other forms like form 5 is kind of other information to be given, like foreign things will be given in the form 5 declaration of the inventorship. And one other form 9 expedited publication, like you can expedite your application by filing form 9, and it is form 18 for request for application, form 26 it is the other form. This actually when you are going to file a patent, you come in the patent office or you search in the website, you can get all the forms clearly there mentioned. So it is not something big deal. So I just describe from how the file form 2, that is complete specification, is the most important part of the patent. So the complete specification is comprised of an abstract, a description, summary of the invention, brief description and drawings, and other than the detailed description, and most fundamentally it will include the claims that what is you are claiming, what product or the process, what you are claiming, device, apparatus, system, method, what are you claiming. This is the most important part via which your patent will be granted. It will be based on this part, this claims. It is mainly, this claim has a two part, independent claim and dependent claim. Independent claim where you can combine all of the features of the product or the process. All of the features you can describe in the claim 1 of the invention of the description. After that, in the dependent claim, you can demonstrate how this other features is coming into the picture. So, firstly, we have to disclose the independent claim. The main part, independent claim, will be based on your method or your device. Then an dependent claim, you can otherwise describe your other the part of the invention, the part of features that is more important. So in this way, you can file the form 2 of the product of the your patent application. So role of the specification and the claims. The claims define the legal boundaries of the invention. That is a scope of the claim will be important. That if you are describing that this invention is valid up to this mark, up to this temperature, up to this pressure, or up to this uh, electric barrier, so up to that, its legal boundaries will be there. Its boundaries will be helpful in utilizing your patent for a common man. The common man can understand your patent, but that your patent is like to work in these boundaries only. If you have a wider boundaries, like you have doing this invention from 0 degree to 1000 degree centigrade of the temperature, then the vast boundaries. If anyone can do this invention in a shorter boundary, shorter scope, then he can get the patent of this. So specific boundaries or legal boundaries should be there in drafting the claims of the patent. So specification actually describe the invention and how to make use of it. So written description requirement, a demonstration process, and it will be assisted by the examples. You have to give examples to your demonstration. Then it will be actually increase the more acceptance from the common man, from the industrial sector, that how they are and how they are exemplifying the invention in terms of the examples. So it is giving the best mode of the your invention. So contents of the patent writing shall be there shall be a title. The title like a vague title like a battery, like a pump. It will not work. After a battery of that diameter, a battery of that work, that will be the exact title. That will not fancy expression, and it is not exceeding 15 words. So it will be very. It will we will actually we will recognize the patent application by the title itself. So title will be from the technical perspective of the application. And the field of invention should be demonstrated like the advantages of the invention and providing the evidence for the support of the industrial application. That is the important one, the industrial applicability. So in the field of the invention, you should tell the advantage that you have got by doing the invention. Then you have to demonstrate the background on the invention. After watching or seeing what you are going for, you have gone for the invention. After something like literature survey, that in the US there is something, US, China they have something, in the India there is something, but they are lacking this thing, they are lacking this process, this aspect. So I am going for this aspect, and via this I am doing this, via this innovation we can justify or we can rectify the process, and we can solve the problem associated with the other inventions. This has been this has to be discussed in the background of the invention as well as the objectives of the invention. So in the detailed description, I will just go to the claim part, which is very important as a part of patent writing. Claim is a statement of technical facts expressed in legal terms, defining the scope of the invention sought to be protected, and what is not claimed in the claim stand disclaimed. As you know, a claim, I already told us, claim is scope. You have mentioned the scope of the claim. The scope should be demonstrated by technical facts, that is inventions ought to be protected. After the statement is been given in the claim, and the part which has been not claimed of your invention, there is some part of the invention used as a experiment. you may not be claiming it in the claim part, but that is important part. But one can notice this distinct part of your invention, and he can also do an invention. So it is very important to file the patent with the exact claims you have, the exact claims, the so it is really important that you file patent with some expertise on the claim part. We as a patent examiner often examine some application which the claims which is given very broad terms, and they haven't examined they haven't experimented in a broad domain of the experiment. So we can discard the patent application that you haven't done the experiment, we haven't shown the examples of the. So this part should be very much careful, and people should also know that the claim drafting, by the claim drafting, they can also grant a patent. They can also get a patent, and they cannot also can be rejected in a patent. So the claims part is very important for the patent. And I know that there may be some machine design. There should be some. Then there should be some figures associated, and there should be an abstract of the total application. That should not be 150 words. In the abstract, you should tell which technical field the innovation belongs and which technical problem you have wish to give a solution. So this will be demonstrated in the abstract part. So how to start drafting? First, draft a set of claims first. After drafting the claims, then only you can go for the specification. First drafts don't have to be perfect, they just have to be detailed. So you have invented something, just go for the claims part. So claims, after defining the claims, you have an idea that I am going in that way to protect my right via the claims. First draft the claims, then you start writing the complete specification, the abstract, the objectives, the literature review you have. So there is a tips of the examiner's perspective that how to file the patent. Conduct a thorough prior search, draft broad claims first, align claims and specification, that something is you are claiming that is not has been given in the complete specification, that cannot be there. Okay, so which is in the complete specification, that only be claimed. So stack your claims like multiple independent claim to define the invention. Clarity is critical. You have to be clear about your invention. You have to clearly demonstrate that what you are inventing in your independent claims. You have to clearly say that we are claiming this product or this methodology in this technical features, with these technical features to get this. In this way, the clarity will be there in the claims. Take help from a professional people. There is patent agent, there are patent agents, so they are helping you in the looking for other patents, that how to file patent, how they have filed patent, they have granted a patent. So you can take help from a professional or in the other patents literature in the you have in your internet. So yeah, there is a provisional specification, which is you have the idea of patenting in your mind, but you haven't completed the idea. But the idea is really important, and it can change the scenario of a whole process. So first you can file a provisional specification that you are aiming this process and you have got a solution, but you are yet to file a patent. You are yet to you a position to justify your invention in terms of technical supports. You need a time to complete your experiment and file a complete specification. So first, you have filed a provisional specification. You get an 1 year time to complete your experiment, complete your all experimental observations. Then within 1 year, you can file a complete specification. But if you have filed a provisional specification, you are getting a patent from the time of provisional specification only. In the middle of something, anyone can know that you are going for this solution, you have invented this, they can file a patent, but you will be getting the benefit as you have filed a provisional specification first. So in this way you can file provisional specification when you have a electrifying idea that you have it will be beneficial for the society. Okay, so an expedited examination to in a startup for small entity who are not in a good financial condition, like a company, they can expedited examination, like they can fasten their examination process of patent filing with the form I have been already been disclosed, that if you one of the applicants is female, the Department of Government and other establishment, and India is a patent searching authority also. So in this agreement, anyone can file for an expedited examination, which can enhance, which can shorten the examination procedure, and you can get the patent granted in about in a shorter time period. So in this way, the expedited examination is also there. So in terms of filing, e-filing, you have actually only requires 5,600 to file a patent for a natural person or startup or a small entity. And other than the startup, their natural, other than the natural person, if any company wants to file, they will have to pay 28,000. So, like a natural person, you have only to pay 5,600 to file a patent. So it is not a big deal for a person, as the filing fees has been already been reduced by the government of India to enhance the speed of filing, and we are also doing the expedited examination. So the time frame has been also been reduced by the government. So it will actually encourage other natural person to file a patent. And the filing procedure is offline submission is not actually not necessarily. You can file it online. Just go to the IP India website of our government. So there you can after getting a then you can file it on your own. There is no need to come to the patent office and file the patent in the hard copy. And the procedure, like we are following this procedure, patent filing, publication, then request for examination. This kind of time frame. This will be, you can know this thing after filing a patent. It's not so important. So what do you mean the patent search? So it's already been discussed that you require a patent search before filing a patent. That where is what alternative products have been available in the market. So you have to look for that what is what other have achieved, what other product or process has been have achieved. So that's why the search is required. If a product has already been known in other country, other domain of the or part of the our country, so that cannot be patented. And you already know that idea has been idea has to be very innovative in nature. So the search is great and cost-effective process. We require anyone who is filing a patent is required a search. And based on the search result, you can modify your application to get the patent. So, how you have been searching patent application, and are you satisfying yourself? if you are satisfying in your result, that yes, we have got some really good experimental results to file a patent. If you are getting a result that is within the limits of other invention which is available in the market, it is not cannot be patented. You cannot get a innovation by doing that. You should have filed should be filing a patent after getting a satisfied result that yes, no one is doing it in my way, uh, in my as my research, as my technical findings. So you have to be innovative in terms of technical features after before filing the patent. Like you can search this, use this search engine. There's Google patents. In the Google, there is a platform is Google patents. Because just searching that, just Google patents. You can search in the Google patents and type the keywords associated with that. So after getting the keywords, you can have that what the patents are available in the market, what the people in the world. After reading these patents, that what are the technical advantage you are getting. This should be done before filing the patent or writing a patent application. So patent search is very crucial, very prudent for the persons who is willing to file a patent. These are the operators you can use when searching patent. So it's kind of genetic and algorithm tuned PID controller. This is kind of example. So what are the important keywords out of this? So case study, genetic algorithm, PID controller, regulator. You can search with that. You can search and tuning and genetic algorithm and process control. This in this way, you can write the keywords in a Google patent platform. Then you can you are getting the problem associated with the market available products. Then you can question yourself, can we tune this PID controller using PSO or any other optimizing algorithm? So this is the question. So you are getting the solution for this problem. So you want to solve this problem. So after getting the solution of this problem, you can file for the patent. So these are the in general what are the actually keywords, key terms, how to search for the patent. This is the examples with that. So research practices to manage disclosure patent. First patent, I file a patent and then publish your research publication. Don't reveal enabling things like in this abstracts or posters. Somewhat when we are going in a conference, we are revealing the important features of the product or process to the public domain, and then they can use it. So first, you have to be very prudent about publishing a patent. First, filing a patent, then go for reveal the original things. So do not use confidentiality agreement in dealing with outsider. When you are going in a conference, you are proposing a solution to a problem. Then many outsiders, many company will ask you for the solution, how you are getting, but you don't disclose the confidential information for your invention. So before filing the patent, so it is really important from the perspective. So in the global innovation index, India actually jumps in the last 5 years, the last 6 years, we have already been jumping in 35 places from 81 to 46 in the last 6 years. So India is getting innovating in terms of innovations, and very from the very beginning it was not there, but now there is an increase in patent filing, and they are getting benefits from the product also. And in a state-wise patent, you can see that the higher patent has been filed in the Maharashtra, and there is the state-wise patent filing signature in India. And collectively, we have seen that IITs has been filing many applications for the patent, There is other university, private universities are there. They are filing patent in the Indian patent system. In the for foreign resident, they are also applying patents for their products or process in India, like Huawei technologies, like uh, Qualcomm, Samsung, uh, and Microsoft. They are applying for the patent in India, as it is territorial right. So they have to file the patent in India also to get their right utilized in India. So this is the website. It is public. You can search engine is also there. Comprehensive e-filing. All informations are in there. So if you are going for the online filing of the patent, you can easily get the information from the website. So in this way, so actually I want to specify on this. The last slide, I will also actually want to specify on this comprehensive e-filing. And after getting public search, you are also let you know that there is acts and rules are there, and the manuals which we follow. Acts and rule and the manuals we follow in the patent office. So you can also know that how this works, patent filing works, and also the controller decision. Controller decision means finally the patent is accepted, patent is granted or not. That is given on the controller's decision. If you go through the controller decision, you can know that how a patent is granted, via which point, via which features the patent is granted. So in this way, you can file the patent uh, in Indian patent system, going with the website that is so intellectual property website. So IPI India, actually I have already given the link of the this website. So this is the website for filing your patent, and you know that there is NIPAM is going on for the IPR awareness. Is from December till 15th of January we are doing the NIPAM. So anyone who is interested in knowing how IPR works, how IPR will giving address to the recent problems we are facing. So they are go for the NIPAM program and learn along with the program. So these are the uh, facts that are available in the website of our government website. So this is all from my side, and I would invite some questions if possible. Actually, we don't have very many time, so if some questions there, please let me know.
Thank you, Dr. Bach, for your interesting speech on the IP Act and IP awareness, all these things. So we will now start our Q&A sessions. So if anybody have any questions on the things that the Dr. Bach is pointed out on this particular topic, so you can ask. Instead of writing the chat box, you can ask directly to the sir. What are the things you need to know, if anything, in your mind? Everybody don't need to write your name in the chat box. Who told you to write your name? You don't need your name in the chat box. If anybody have any question, then you can ask. It's a free, open and Q&A session, so you can ask anything on this particular context. If anybody any question? So Dr. Bach, in this contest, I have one question. In the beginning, you have seen that one textile design on the sari and like this. So previously, I am working with some rural artisans who are actually making this kind of katha stitch design, and they are doing some kind of Madhubani painting on that. So if that artisans are trying to do the filing the patent on this context, so should they focus on their design or the color combination or what? And on which aspect they will just start thinking on that?
No, you are going for the design, right? So in design, when you are applying for a design for the product,
yes,
both of the combination, color combination, and the design perspective is important. So your original work is there, and like a design is original from it is other products. So you are just concentrate on the uh, concentrate on the product, that is design, and along with the color combination.
Both they will focus on the design at the same as the color, texture and the colors.
Okay, yes.
It is not the product specific.
No.
Okay, because some of they are doing the collaborative work. That means some of are doing the painting of this kind of Madhubani painting on the T-shirt also. Which
No,
is
actually,
the
no.
traditional
The
thing in-
Madhubani painting is originally already been under GI. You know
right,
that.
right.
So combination is there.
Right.
Then they are going for the design, and they are applying for the design. They should focus on their design first, and the color combination, as well as the color combination,
Okay.
which will differentiate other products from their product. Okay.
Because in our village Pingla, in our West Bengal, in the Medinipur, so they are doing the Potochitra also, pot shilpi. They are doing the traditional god painting, all these things. So right now they are doing this god painting on the umbrella, on the T-shirt, on the different items to reach their marketability. Okay, thank you, sir. Thank you for your valuable input on this. So in this contest, I will just like to invite our Dean of Research, Professor Dr. Ashok Shah, to just conclude this session. Sir, are you there? Ashok, sir?
Yes.
Yes, sir.
Yes. Am I audible, Janto sir?
Yes, sir. You are very much audible.
So, good afternoon, everybody. On behalf of Budge Institute of Technology, it is my great pleasure to convey my sincere vote of thanks to renowned personality, Dr. Kaushik Bagh from Ministry of Commerce and Industries, Government of India. Sir, thank you for sparing your precious time for our college, for our faculty members, students, and all of us. Sir, you enriched all of us by your both presentation. In part one, you presented different kind of innovations which has been made, and the kind of innovations which can be patented or can have a copyright also, or design filing also.
100 रुपये मात्र में
Sir, you are not audible. I think you want to unmute yourself.
Okay. So am I audible, sir?
Yes, very much audible.
Yeah. So, sir, in part one, you enlightened all of us about the different kinds of innovations which has been made and can be made in future also, and that can be filed for patent or design or copyright, all these things. In part two, you just enlightened us about how to file a patent, or how to go for copyright, or how to go for designs. So all these things you enlightened us, and hopefully all our participants have been enriched by your presentations. So once again, thank you very much, sir, for your precious time which you given for our faculty members and students and our college. I would also like to thank our Honorable Director General Academics, Sir, Dean Academics, Sir, Dean Student Affairs, Dean of MBA, Dean of IT and ECE for their encouragement and support. I would also like to thank all members of the organizing committee of this program, and especially the convener, Mr. Jayanto Basak, sir, for organizing all these things, all these coordinating all the programs so smoothly. I would also like to thank the whole IT team, especially Mr. Amit Gupta, for facilitating the platform, and providing us the facility of recording all the programs for today's. So thank you, Amit sir, for your support. I would also like to thank all HODs, all TICs of my college for circulating the informations among their faculty members and students, so that we have reached the extreme number of participants today, extreme possible participant today. Without your support, it was not possible, sir or madam. I would also like to thank my management of the college. Without their encouragement and support, such kind of activities are not possible. So once again, I would like to thank all the management members of our college. Once again, I would like to thank all other members of the college, all supporting staff of the college for extending their support to organize this program. So thank you very much, everyone. Over to you, Jayanto sir.
Sir, just a small request to Dr. Bag, if possible, you just share the PPT with us so that we can circulate among the students and the faculty members and the staffs who are interested to, if you don't have any problem for your side.
All right.
You just share the previous presentation, and it will be very grateful for us.
All right.
So, okay, sir, we'll just conclude our sessions here. Thank you, sir, for your time, precious time.
Thank you.
Thank you, all DPS sir, Bhavesh sir, for your inauguration speech, which actually motivates us to conduct this kind of program in the near future.
Thank you.
Thank you, sir. We will just conclude our session here.
Thank you
very
very
much.
much. Thank you very much.